District Court of Appeal is now open. All that business before this court draw near, give attention, and you shall be heard. God save the United States, the great state of Florida, and the
Please be seated. We have 4 cases on the docket this morning. We're going to take them in the order that they appear. We are going to take a break after the first case and invite the lawyers to join us for coffee in the Commons for about a 15-minute break after the first case, and then we'll resume. General announcement, if you are the appellant, you can ask me for time for rebuttal, and I'll try to remind you, but you're going to be ultimately responsible because the clock is in front of you. All right, the party's ready in the case of Rapid Management versus Board of County Commissioners.
Yes, Your Honor.
Your Honor, I'm Jesse Rigby. I represent Rapid Management Company. I'm from the Pensacola office of Clark, Partington, Hart, Larry Bond, and Stackhouse, and I would ask that I be allowed to reserve 5 minutes. Your Honor, if it pleases the court, without directly stating so in its brief, I believe the county poses a direct attack on this court's December 2009 decision in M&H Profit versus City of Panama City. The county states that the panel deciding that case last December provided no case law to support its theory that the enactment of an ordinance of general application such as the county's wellhead protection ordinance would not constitute a specific action of a governmental entity because it related to the general welfare of the community. As this panel knows, M&H Profit was a case of first impression. This court held that the specific language of the Burt-Harris Act does not contemplate facial challenges to general health, safety, and welfare ordinances. I submit, Your Honors, to leave this summary judgment in the instant case intact. You must explicitly overrule M&H Profit.
Let me ask you something, though. You were told sometime prior to June 1st of 2006 that a variance needed to be requested.
That's correct. My client was, yes, Your Honor.
Yeah.
That was actually in the time period after the application was filed in early May 2006, after it was the application for the county development order permit, which was first required by the March 17, 2006 ordinance.
Okay, but you would agree that there was no, as the county leader held, there was no procedure in that ordinance to obtain a variance, correct?
No, Your Honor, I believe there was a procedure. And if you'll go to the county's brief itself, it cites the variance ordinance. And that provision, I believe it's on page 2, I may be wrong on that, but early in the answer brief, it cites it. And what it says is that variances are available in Escambia County to all those provisions of the Land Development Code covered by Articles 4 and Articles 7 through 12. The Wellhead Protection Ordinance is 7.12.
Okay, so you're challenging that determination. I mean, you're not.
No, we're not challenging it. It's history, Your Honor.
Okay, history. Well, but I'm glad you brought that up, though, because I mean, my question to you was, if a variance was not available, would that toll the time for bringing the Burt-Harris challenge?
It would toll the time. Let me back up, Your Honor, and put this in perspective. The variance application was not futile, and there was a variance process. Now, it was later determined several months later by the planning board that has the power in Escambia County to make these interpretations that under this specific instance, the county would not grant a variance or could not to that specific requirement. But that had never been determined before. So that was during that process. But I believe it's subsection 11 of the Harris Act provides for a stay during the time that an owner is proceeding with any administrative procedures that are available. And I submit, Your Honors, that, quite frankly, if we had not submitted for that, we would have had a rightness challenge and a claim to it. So we did. The county staff recommended the variance process. You'll see from the record the county staff recommended that the variance be approved. Their staff report was provided to the Board of Adjustment. It was only when the county attorney's office at that Board of Adjustment hearing said, we don't think you have the power to order a variance. And they said the appropriate procedure is now to go to the planning board for that interpretation, which we did. The planning board determined that it was not available. Now, we could have taken that to circuit court, but at that point in time, we had completed our administrative processes with the exception of the completion of the permit application. The county hadn't ruled on it yet. So it would have been a waste of my client's time and money to go to circuit court. The handwriting was on the wall. Even if we had prevailed, at that point in time, we were never going to get a variance. Your Honor, without overruling M&H Profit, can this court uphold the trial court's decision that as a matter of law, the purchase of a parcel of property without knowledge of the existence of an ordinance of general applicability to the entire county applies that old regulation to the property where the county has taken no affirmative action concerning the ordinance and the property? I think that's the issue.
Okay, but if affirmative action had been taken prior to you buying the property, then you would be on notice of that. Isn't that correct?
If action had been, but it hadn't. All that had was a mere enactment. If, for example, if the county had taken action against the Kingreys between June 1, 1999 and March of 2000 and issued some order, said you will cease and desist from any other storage of, because they were using the facility at the time, not for C&D, but for land clearing. If they had said you will cease and desist, I would agree that would have applied. That would be like a code enforcement action being applied to that piece of property. And I believe the owner, the second owner, would have been on notice at that point in time. But it would have been a specific application of the ordinance to the property, Your Honor.
Okay. But I'd like to address, because what I'm having some concern about here is while the trial court did not rule on the question of whether you had a Burt Harris challenge, you would agree that you either have to show, I guess the wording is that there's an existing use or you have a vested right.
It's not, the provision is an actual existing use or a vested right. Or, and if I try to quote that off the top of my head out of that statute, Your Honor, it's a little bit difficult, but quite frankly, are such reasonably foreseeable non-speculative land uses which are suitable for the subject real property and compatible with adjacent land uses and which have created a fair market value in the property greater than the fair market value of the actual present use. And so, yes, those are trial-level determinations on liability to be made by the trial judge. Those are not summary judgment issues. In this case, and I submit seldom in any case are they summary judgment
You're reading
issues.
that as a three-part actual use, vested right, and then the language you quoted at the end.
Your Honor, I wrote a paper some time ago that early in this process, and I said if the only thing here, if equitable estoppel was all you had, if that's all that the Harris Act provided, we didn't need it. We have claims to apply equitable estoppel against the county outside the Harris Act. So that really doesn't add much. You could have a Harris Act case today with an equitable estoppel argument, but that is not required. That is only one of three.
Okay, but I understand. You're saying it's a three-part process. But as far as number one, we didn't have an actual use here allowing you to do the construction debris. That was not existing on the property.
I'd submit, Your Honor, that's questionable because when the county adopted its first ordinance, that's 2006-24, it defined construction and demolition debris to include land clearing debris. So land clearing debris by the county's definition is construction and demolition debris. Before that time, I would have said it would have been questionable.
Well, but nobody is questioning the right, even your right now, to do land clearing debris on the property, are they?
There's been a code enforcement officer out, but they've never issued an order. Now, that's not in the record. That's not in the record. It has continued to operate. It has surprised me. The county has never tried to shut down the land clearing debris. It has continued to operate. And that's from the record as of that date.
So the actual use we're talking about that you're saying you're being deprived of is the construction debris.
That is the reasonably foreseeable investment-backed expectation that created a fair market value in the property greater than the fair market value of its use for land clearing debris. That's that third portion of the definition of existing use. But those are trial-level decisions on liability to be made by the trial court, Your Honor. not summary judgment decisions. Your Honor, looking a little more closely at the facts in this case, again, we see that prior to March 17, 2006, that's when the county adopted Ordinance 2006-24, the county did not require any landowner to obtain any form of permit or authorization to operate a C&DD facility. All the owner needed was a state permit. Rapid Management had that permit issued in September 2005 and would have been in operation shortly thereafter, but for one fact. The county had issued a moratorium in February 2005 that precluded the opening of any new landfill-type facilities. And, of course, the Harris Act tells us that the moratoriums are appropriate, and that does not trigger a Harris Act claim. So, but for the moratorium, though, the operation would have started, and it would have been up to the county then to come forward and apply some form of action, such as code enforcement or a misdemeanor violation, to try to shut down the operation after it had started.
Okay, Mr. Rigby, help me here a little bit, because, I was trying to listen to you and I didn't have the statute in front of me. So I want to go back to a question I asked before. Subsection 2 of the statute says, when a specific governmental entity has inordinately burdened or existing use of property or a vested right to a specific use of property, the property owner of that real property is entitled to relief. Then the third prong, I guess you're getting out of the definition of existing use.
Yes, Your Honor. In 3B. Existing use has a very specific definition, and in some of the articles
but it talks about being, but reading words out of there, it seems to me.
I'm sorry?
The term existing use means an actual use, present use, or activity on the real property, including periods of inactivity which are normally associated with or incidental to the nature, type, blah, 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 blah. Are you arguing here that this was just merely a period of inactivity on the property?
No, Your Honor.
I have trouble reading that third prong in unless we're talking about a short period of inactivity.
It uses the term or, Your Honor, not and. It says, or such reasonably foreseeable, non-speculative land uses that are suitable for the subject real property and compatible with adjacent land uses. Your Honor, I submit that occurs many times when you have a piece of property that is vacant property, but you may have a plan to put condominium on the property, quite frankly. If the county specifically downzones that property, is that a reasonably foreseeable land use that was compatible with the neighborhood? That is, I think, a very distinct prong. But again, maybe more importantly for this proceeding, I believe, Your Honor, that's an issue of liability.
I'm not so sure it's not important for this procedure. And the reason I'm saying that is clearly, and you're down 3 minutes, I'm sorry.
I know.
Clearly, we don't have an existing use in the property. I really have a problem seeing that we have a vested right here.
We have not claimed equitable estoppel, Your Honor. I admit that.
Those two, if it's not an existing use and it's not equitable estoppel, isn't the argument, and you're saying there's no factual dispute on that, can't we rule as a matter of law that period of inactivity, that language only applies to a period of inactivity? Do you understand my question? It seems like you're framing this to me as a legal issue as to whether there's a third prong to that test.
I think there is a third prong by the wording of the statute, Your Honor, and that is that you look at the uses of the property that be reasonable and otherwise allowed.
I understand that, but why doesn't it become a legal question, which is appropriate for summary judgment, as to whether there is a third prong to the Burt-Harris test?
Your Honor, if we follow statutory interpretation, it's there, it says it's there, and unless the legislature wants to take that out, I submit that was, unless the legislature wants to take that provision out, it is a third prong.
Okay, I understand your argument, but that's a legal question one way or another, which would be appropriate for summary judgment, right? As to whether there's a third prong.
I guess it would, Your Honor. That was not addressed in any manner, and even in the briefs. And so I would go back to Lomax v. Mowry and other cases that it becomes somewhat unfair, even though we can talk about the tipsy coachman doctrine and what it might do. If it's never been addressed at all below, I suggest that it might not be appropriate. And
no, I understand that, but you started out saying there was a factual dispute.
There's a
It seems to
factual
me it's only-
dispute.
it becomes a factual dispute if you say there's a third prong to the test.
I guess that's correct, Your Honor. And at that point, the question is, what are the reasonable investment-backed expectations of the owner of the property? I believe that is clearly a factual determination.
Okay.
Thank you.
Tell you what, you're down to 1 minute and 15 seconds, but since I question you, why don't we add 2 minutes to the other side and give you an additional 2 minutes for rebuttal?
Thank you, Your Honor.
May it please the Court, I'm Charlie Pepler, I represent Escambia County. Your Honors, the issue in this case, as I see it, is when does this Burt Harris claim ripen? Does it ripen when the county passed an ordinance, the Wellhead Protection Ordinance, which allowed no discretion on the part of the local government entity here, Escambia County, to grant any variance or exception as to a category of prohibited uses? And the first use listed under those prohibited uses was a sanitary landfill and a construction and demolition debris pit. That ordinance went into effect on July 1st of 1999, approximately 9 months before Rapid Management purchased the property. Ms. Kingery was the legal owner at the time that the ordinance went into effect. If anyone has a claim, it would be Ms. Kingery. If she's going to claim that certain existing uses that I had for that property or vested uses were permanently limited or restricted by the Wellhead Protection Ordinance. Rapid Management has no claim. They have no claim because of the fact that they let a year go by before they took any action. I disagree with Mr. Rigby as far as the effect of the 2006 ordinances. The 2006 ordinances just created a situation where there was better delineation of reclamation pits or borrow pits and reclamation of construction and demolition debris landfills and where they would be situated. And the county did institute a development permit review process for those landfills. But by instituting that 2006 ordinance scheme, it didn't supersede, it didn't amend, and it didn't abrogate the Wellhead Protection Ordinance. That still is in effect. And what Mr. Rigby is basically arguing, the variance that he wants, he knows he can't get it from the Wellhead Protection Ordinance. So the variance he wants, he's arguing that actually when this new statutory or ordinance scheme went in effect, that's the variance he wants to the County Commission or the Board of Adjustments to appeal. And quoting from what Mr. Rigby stated at the Planning Board on September 11th of 2006, if you recommend or you concur with the county attorney's approach that no variance can be granted, there is absolutely no relief. And Mr. West, he was the assistant county attorney, will tell you there's no conditional use. There's no need for a zoning change. We don't need to change zoning. There's no variance. There's no administrative appeal. There's nothing. So, and then I'm skipping. So what we ask you again, using the new landfill ordinance, meaning the 2006 ordinance, and the county's commission's direction that you can get a variance from, I don't know how that doesn't quite frankly resolve our issue here. So what he's arguing is not the ordinance which poses the death.
Okay, let's go back a second, though. I understand that. Your position is it's the initial ordinance that was the application to this particular piece of property.
Correct, Your Honor.
And it's very, very apparent you don't like our decision in profit. However, having said that, and I would point to you to one thing that there are a lot of decisions here where we decide cases where they're not cases on point before, but we get to read the statute. So the fact that there weren't any cases.
Right.
Okay. But assuming that our decision in profit was right, which I know you don't want to concede, but assuming it is, tell me how the mere passage of this ordinance in 1992 or whenever it was is an application to this particular piece of property.
And I was prepared for Your Honor to make that statement that M&H profit could still be good law. I think it still can coexist with our Wellhead Protection Ordinance and with the Halls River versus Citrus County because of the fact that I believe the ordinance in effect by Panama City had to do, there was some discretion. If you read between the lines and you were the author of the opinion, you were close to that ordinance. There's some discretion given as far as the height and setback development standards. whereas in our wellhead protection ordinance, there's no discretion. And you also made the point that the M&H profit people had not gone through the development process. All they were doing were relying on, I think, an assistant city manager saying, no, you don't have any case, go away. And what you were saying, well, you can't really rely on representations of city personnel, just like RMC can't rely on erroneous representations from the county personnel as to whether there's a variance or not. And I think it's distinguishable on those grounds, as well as the other ground that you made at the end of the opinion, that Halls River applies to a particular parcel of property. And I believe when you look at the Northwest Water Management report, there's 56 wellheads that we're seeking to protect, and there's 56 particular parcels of property or areas of property that are within that 7-year travel time contour. Therefore, I think that's another distinguishing factor, is that we are protecting particular parcels of property, which include Rapid Management's property.
Since there was a map, I'm going to put words in your mouth, and then I'm going to play devil's advocate with you. Your position basically is that since there was a map describing particular pieces of property, this was very much akin to a rezoning?
No, not a rezoning. I'm saying that I'm trying to go along with the M&H profit opinion that Halls River doesn't apply because, you're right, Halls River doesn't apply because Halls River talked about a particular piece of property, that acreage that was rezoned from MX to LC, which is low intensity coastal. And that was the last concluding sentences of your opinion. And all I'm saying is, in this particular case, we do have particular parcels of property that are affected by our wellhead protection ordinance, and therefore Halls River would apply and can live alongside of M&H profit. The other points I wanted to make with regard to the issues apart from facial application and as-applied application of the Burt Harris claim is in applying the unfortunately named Tipsy-Coachman rule. I think the summary judgment can be sustained under the fact that no new ordinance was ever applied to Rapid Management. They came to the property with constructive notice that this ordinance was in effect, and they were, all the bundles of rights that they had when they purchased the property in March of 2000, they had with notice of that wellhead protection.
Can you address the argument whether the Burt Harris applicability, that there are 3 prongs to that versus 2?
I think the 3-prong argument, I agree with Mr. Rigby in subsection 2 that there has to be an inordinate burden on existing use and a vested right to a specific use. But if you go to subsection 3E, the statute defines what an inordinate burden is. And under 3E, it talks about that he's unable to obtain the reasonable investment-backed expectations to an existing use, a vested right, or he's left with existing or vested uses that are unreasonable because now he has to bear a disproportionate share of the burden imposed for the good of the public. And I think that's where that 3rd prong comes in. But
You will answer this question. If there is not an existing use on the property that's inordinately burdened, or if there is not equitable estoppel or whatever the term that they use here, vested right, does someone have a right under the Burt Harris Act, cause of action?
Well, using that other definition of an inordinate burden, it would seem that they're left with existing or vested uses that are unreasonable. So there's that 3rd catch-all. So, and if I'm going to play the devil's advocate against my own client, I guess Rapid Management's argument is that I'm left with an unreasonable use of this property as a land clearing debris or sand mining because of
Have they ever made the claim? It seems to me that that claim has to be that any use that they can make of the property would be unreasonable. Have they ever made that claim?
No, Your Honor. My reading of the record and their complaint...
I'm not sure you're advocating very well for your client, to tell you the truth.
Who, me?
Yeah.
Well, my argument is that they, when they had the ownership of the property, they had uses consistent with our landfill ordinance, the wellhead protection ordinance, and also with our other ordinances, and the fact that they could use the property for land clearing or sand mining or whatever they wanted to use it for. It just wasn't particularly profitable for Rapid Management to use it for those purposes.
But the fact that it is not that much profitable, would that affect support of Bert Harris claim?
No, Your Honor.
Okay, thank you.
Okay. That's all I have. Thanks.
Your Honors, if I might, I'll try to address some of those points. I'm going to go back to existing use. Your Honors, existing use is a defined term in this statute. And every time it is used in that statute, whether it's in sub 3E or wherever, we have to go back to that defined term to correctly interpret that. That's where I get my argument. Is there any evidence of unreasonable?
Yeah, I'm sorry, you were going back to 3B.
3B, because you always got to go back to 3B. And it is a uniquely worded provision. It is not the actual present use. If it was just actual present use, that would be, in most cases, Bert Harris, vacant land. That's in many cases. So it means something. It means something quite different. As far as whether there's use is unreasonable, that's the process of submitting the appraisal. And we submit there is. Because what the Harris Act really says is, as a policy matter, there's nothing wrong with the county imposing an ordinance that restricts the use of land. What the Harris Act says, though, if that happens, and if it's being done for the public good, as it has to be lawful, then in certain circumstances, if it inordinately burdens an existing use, as defined, which has reasonable investment-backed expectations as part of that definition, then that imposition should be borne. The cost of that should be borne by the public, just like eminent domain. It should be borne by the public as opposed to the individual property owner.
I guess my concern, and you may be right, does Bert Harris mean that even if I have land that is not zoned for a particular purpose, but I look around and see that, the other uses in the area would be compatible with what I want to do? And I'm sorry, this is a long question, but I'm trying to think it out. That when I go in and buy the property, I have the Bert Harris Act, even though the property's never been used in that particular manner?
I'm sorry, Your Honor.
Go ahead. Try to answer it. I mean, that's a long question.
There are two issues there. Number one, do I have a claim in the first instance? And in your position that you've just posited, I doubt that I have a claim. I surely don't probably have a claim that's inordinately burdened if you start evaluating that claim. If I get over the hurdle, though, the question of whether or not there's an inordinate burden and whether or not my investment-backed expectations are reasonable is a trial-level decision by the trial judge based on the facts. It's kind of like the constructive notice argument. Your Honor, these are those maps. You've seen them in the record. This is what the county provided, and I would suggest to you that's what was on notice. And in the county's affidavit at the motion for rehearing, they offered the wellhead protection document from 1997, the Water Management District. If you go to pages 1502 to 1515 of the record, you're going to find somewhat better maps, but not much. You're going to see little circles on big maps, and the county now tells us that allows somebody to know that their property has been singled out and that this ordinance has been applied to their property. Any land use ordinance of general applicability, including M&H profit, is if you search hard enough and go far enough, you might be able to find that there's some impact of that property on your property. But in the Harris Act, we're talking about a new ordinance after 1995, May 11th, that was imposed as it was in this case. And
Mr. Rigby, your time's up. Thank you.
Thank you.
We're going to take a 15-minute recess. We invite you to join us in the Commons for coffee.